Okay, recording is started. Feel free to begin presenting.
Welcome to today's program titled Equal Pay Day 2022, Key Trends in Pay Equity. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box at the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down as it will not be reread and is required for CLE credit. Copies of the webinar recording and materials, along with the CLE attendance form, will be distributed to attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. At this time, I would like to turn it over to our first speaker for today's program, Annette Tyman. Annette, please go ahead.
Thank you, everyone, for joining us. We are thrilled to have you today to talk about issues related to equal pay. It is an important day, as you will hear much about Equal Pay Day. There's been a lot of press releases and notifications that have already gone out today. And at Seyfarth Shaw, we wanted to take a step back and really think about what are some ways that we could really add value to the conversation here. And I'm thankful to be joined today by a team of associates that together we all work on equal pay issues as a significant part of our practice. So we are hopeful that today we can share some of those insights with you and begin a conversation that we anticipate will last throughout the upcoming the course of the year. So today I'm joined by Sharday Skahand, who is out of our Los Angeles office, Christy Ayokapeta, who's in our New York City office, and Maria Papasavastos, who's also in our New York City office. I should have introduced myself, I suppose. My name is Annette Tyman. I co-lead our pay equity group and our people analytics group. And so through that, we spend a lot of time talking about equal pay issues, as well as other things like diversity and inclusion. Of course, pay equity is a part of that. If we as we move throughout the day, we have prepared some new resources for you as shown on our next slide. There's a lot of information that has gone into the work leading up to today and through the upcoming year. So we will have to share with you later today is a global desktop reference that outlines some of the issues that impact employers on a global basis. Those are primarily outside of the US. We will also have a 50-state pay equity desktop reference that provides some of the key issues that common questions that come up, and we're outlining all 50 states and whether those states have, for example, salary history band information. So that information will be laid out. And then finally, our third resource for today is going to be an equal pay litigation update. These are all ebooks that we will be sharing with you as we continue the conversation on pay equity issues. And as we look ahead into 2022 and beyond, what is it that we continue to see? The first issue that we see is, this continued rise from state laws. That's where we're seeing a lot of action, and it's around pay scale disclosures. So providing some information to applicants. Every state is dealing with it a little bit differently. We'll talk about that today in terms of disclosures, and this aligns with the transparency considerations that many employers are seeing. Many states are requiring. We're also going to share some information about global pay data reporting, and Sharday will walk us through that information. Another area that we are seeing in 2022 and beyond is just what I will refer to as a general stakeholder interest. That is pressures coming from multiple groups. It could be from employer groups that are seeking additional information, stakeholders such as, a request from a shareholder proposal that comes out seeking pay data, Boards are requesting information and requesting greater transparency from their own employers. Employee groups, employee resource groups are asking for additional information and requesting transparency. We see unions doing their own pay data analyses and requesting additional information. Just a wide variety of different stakeholders, the political groups, and we see lots of agencies and departments of the federal government seeking compensation data. So that's another area that we will we won't go through those as much today, but it is definitely a pressure that we're seeing, and that's part of what we will be having additional conversations about. COVID-19, we will certainly talk about that today, and the Great Resignation and how has that played an impact on pay equity issues. And then finally, increased litigation. We won't spend time today talking about the litigation, but all of these issues are leading towards increased litigation. We are already seeing that. We are certainly seeing in California, for example, laws that began there in 2017, 2018. We are seeing those play out in state equal pay litigations. And so today we're going to focus more on the proactive side, on the administrative requirements at the state level, pay reporting, and that's going to be our focus today. But certainly against all of this and the backdrop and the complexity of pay equity, we certainly see an increase in litigation. So with that, I'm now going to turn it over to Maria, who's going to kick off our discussion regarding the pay scale disclosure requirements.
Thanks, Annette. So as Annette mentioned, a major trend that we're seeing in the pay equity landscape has to do with a push for greater transparency. And the way that many states are addressing that is through these pay scale disclosure requirements. Several states have adopted laws that require employers to provide either applicants or both applicants and employees with wage range or rate information for their positions. These jurisdictions on the screen are those that currently have some type of pay scale disclosure law in place. The newest being New York City, which is effective May 15th. And Rhode Island, which has an effective date a bit out in the future of January 1st, 2023. So we're really seeing a trend in this with more states jumping on this and having pay scale disclosure laws. And the requirements vary from state to state, not only in terms of to whom a disclosure has to be made, whether it's an applicant or an employee, but also what will trigger a need to disclose. The requirements also vary in terms of the information that must be provided. Many states require a wage or salary range, but Colorado also requires a general description of bonuses or commissions or other compensation being offered for the job. And Colorado also requires a general description of employment benefits that are being offered. So again, the requirements really vary based on which state you're dealing with. But looking at the big picture here, there are really three buckets in terms of how the states adopt these pay scale disclosure laws. The first is states that require disclosure upon an applicant or employee's reasonable request. Those are states like California. There's also states in the second bucket that require a proactive disclosure from employers to applicants or employees. And then the third bucket of these types of laws is states that require a disclosure on a job posting, like Colorado or New York City's new law. So if we can go to the next slide, we'll take each one of those buckets in turn. So these states here are the ones that are in the first bucket and that currently have pay scale disclosure laws that require disclosure upon an applicant or an employee's request. And the timing varies in terms of when the requirement to disclose is triggered. In California, it's triggered upon a reasonable request. And the state defines reasonable as a request made after the applicant has completed an initial interview with the employer. Now, we'll note here, though, that There is pending legislation in California that may change these requirements. Sade will cover that a bit more later in our presentation. But if the legislation is passed, the basic gist of it is that it's going to require pay scales to be disclosed in job postings. And there's also a promotional opportunity piece so that it would come out of this bucket and more into the Colorado, New York City type of cases, types of states. So then we have Maryland. The requirement to disclose in Maryland is also triggered upon request. And there's no limiting language in the Maryland law about it being reasonable, and no specific point during the hiring process that marks when an applicant can actually ask for wage range information. Next is Cincinnati and Toledo in Ohio. The requirement to disclose in these states is triggered upon reasonable request after a conditional offer of employment. So it's a bit later in the hiring process in these cities. Next is Washington State, which is also upon request. Currently, Washington requires disclosure for applicants upon request only after an initial offer is made. And for current employees, it's the same, but it's for an offer of transfer to a new position or promotion. So it would be only after the current employee asks for the information after being offered a new position. I'll note here also that Washington has pending legislation that will likely change these requirements as well, so that it's more in line with Colorado and New York City, and would require a disclosure in the job posting. As of this morning, the legislation is on the governor's desk for signature, but has not yet been enacted into law. In terms of what must be provided, the screen here goes through that. California law requires the pay scale be disclosed, which means the salary or hourly wage range. In Maryland, the term used is wage range. In Toledo and Cincinnati, the term is pay scale. These terms are all undefined, however, and there hasn't been any additional guidance on how it's defined. And then for Washington State, there are separate requirements about what must be disclosed there. If we could go to the next slide. So the next bucket and category of state requirements is those that have the affirmative disclosure requirements. In Connecticut, the timing for applicants is the earliest of the applicant's request or prior to or at the time of an offer of compensation. So this is a proactive requirement to provide wage range information at the latest at the time that you offer compensation, unless the applicant were to request the information first. The timing for current employees is upon hire, upon a change in the employee's position, or the employee's first request. The Connecticut Department of Labor has issued some FAQs on this law, but the guidance doesn't really specify what's considered a change in the employee's position. So what we've generally advised is that it be provided when there's a transfer as well as when there's a promotion. As for what must be provided in Connecticut, there is a requirement to provide the wage range for the position, which it defines to mean the range of wages the employer anticipates relying on when setting wages for a position. And it may include reference to an applicable pay scale, a previously determined range of wages for the position, the actual range of wages for the employees currently holding comparable positions, or the employer's budgeted amount for the position. Now, in Nevada, the timing for applicants is upon completion of an interview for a position. Just to give a bit more insight into this law, for companies that may have multiple screenings or interviews for a position, the law doesn't specify at which point in the process the disclosure is triggered if you have multiple interviews. But during the Nevada Assembly Committee meeting, when the law was being considered, An Assemblywoman raised a question regarding the bill's requirement that it be provided, the wage range. And the question related to even if someone wasn't offered a position, would you still have to disclose the wage range? The response from the senator who co-sponsored the bill was that yes, the law still requires employers to disclose a wage range or rate information to all applicants, even if they're not being offered the position. And the purpose is so that during the salary negotiation process, an applicant doesn't feel compelled to disclose prior wage information, which the employer could then use to set the salary range or rate. The senator compared the disclosing of a wage range to discussions during the interview process about everyday job duties and to whom the employee would report. So even if the applicant doesn't get the job, the senator explained, the interview is talking about the applicant about what the position may entail. So based on that, it would seem the appropriate time to disclose a wage range would be at the point in the interview process when the interviewer and the applicant are discussing more concrete details about what the job will entail. But of course, Nevada could take a stricter approach to this, but that kind of seems to be what is intended here. And it's consistent with this approach generally in these states about having greater transparency and wanting to give applicants and employees information about the different pay scales at different levels. So for current employees in Nevada, it's not a proactive disclosure. It's like it is for the applicants. It's rather when an employer has to provide wage range information for a promotion or transfer to a new position. If the employee has applied for the promotion or transfer, has completed an interview or been offered the promotion or transfer, and has requested the wage or salary range for the promotion or transfer. In Rhode Island, the applicant disclosure is triggered upon request, and the law states that the employer should provide a wage range for the position the applicant is applying for prior to discussing compensation. But for Rhode Island, for applicants, it's upon request. Now, for employees, this is where the disclosure is triggered at 3 different points during the employment relationship. It's first at hire, it's when the employee moves into a new position, and then the third time it's triggered is upon the employee's request. And Rhode Island, again, defines wage range a bit differently, as all these laws do. Next slide, please. So the third category of states are these states that require a disclosure in the job posting. And Colorado was the first state to adopt this job posting requirement, and so far appears to have the most far-reaching implications for employers. So employers must disclose the hourly rate or salary compensation or a range thereof on job postings, or provide some other form of notice for current Colorado employees, and must also provide a general description of bonuses, commissions, equity, or other compensation being offered for the job, and a general description of all employees of employment benefits that will be offered for the position. New York City, which is the newest of these laws, and follows Colorado in requiring the wage range information in the job posting, that one requires the minimum and maximum salary being offered for the position. If we go to the next slide. So given that Colorado has the most far-reaching implications of these laws, we thought it would be helpful to go through Colorado in a bit more detail. The state Department of Labor has also issued rules and extensive guidance on the law, so there's a bit more to go on when determining how this law is actually applied. And we look to Colorado sometimes in interpreting how the other laws are applied as well. So the first requirement is to announce job opportunities that are available to employees in Colorado. This is the promotional opportunity disclosure. So more specifically, the law says that employer must make reasonable efforts to announce, post, or otherwise make known all opportunities for promotion to all current employees on the same calendar day and prior to making a promotion decision. We'll get into this in a bit more detail in a moment. The second general requirement is just to disclose pay information for jobs in Colorado and for remote jobs that can be performed in Colorado. This is generally referred to as the compensation information disclosure. There's also a third record-keeping requirement that says an employer must keep records of job descriptions and wage rate history for each employee for the duration of employment plus 2 years after the end of employment to determine if there's a pattern of wage discrepancy. Next slide, please. So for jobs in Colorado and remote jobs that can be performed in Colorado, there are 2 requirements on employers. They must provide notice of promotional opportunities and compensation information disclosure, which is what we had just covered. There are some exceptions to the promotional opportunity notice requirements. That's for entry-level roles, for confidential searches, and for temporary roles. But these exceptions in the guidance are very limited in their application and pretty strictly construed. So under the promotional opportunity requirements, the requirement for what constitutes a promotional opportunity is really any job that's superior to another job held by one or more employees in terms of compensation, benefits, status, duties, or access to further career advancement. So promotional opportunity is pretty broad in the way that the law is considered. And a quick note on qualifications also for promotional opportunity is that the guidance specifies that the promotional opportunity notices cannot be restricted to jobs that Colorado employees would be eligible for. So you can't limit the promotional opportunities that you give your Colorado employees notice of based on who you deem is qualified for that opportunity. And another kind of note on these promotional progressions is the guidance specifies that inline or career progression promotions are expressly considered promotions in the guidance. So that would be like from accountant 1 to accountant 2 as a progression. That would be considered a promotional opportunity for which you would need to provide notice. The guidance provides a bit of an exception where an employer continuously, meaning at least once a month, hires for specific positions that would qualify as a promotional opportunity or automatically promotes employees for inline job progressions after completing certain requirements. So there is an exception for that, but again, the exceptions are very limited under the Colorado law. And for jobs outside of Colorado, this slide just goes through that employers with Colorado employees are required to provide notice of promotional opportunities to their Colorado employees, even if the job is located outside of Colorado. And if the job is located outside of Colorado, employees with no Colorado employees do not have to provide anything. So next slide, please. In terms of what information must be disclosed, the compensation information disclosure requires the hourly rate or salary compensation range. It requires a general description of any bonuses, commissions, or other forms of compensation being offered for the job, and a general description of any benefits. The notice of promotional opportunities, which goes to your Colorado employees, that requires the job title to be in there, the means by which the candidate may apply for the position, and if applicable, so for jobs that are performed in Colorado or remote jobs that could be performed in Colorado, you must also include the compensation information within that notice of promotional opportunity. Next slide, please. So as noted earlier, New York City is the most recently enacted pay scale disclosure law, and it goes into effect on May 15th. So following Colorado, it requires information within the job posting. The law makes it an unlawful discriminatory practice for an employer, an employment agency, or an employee to advertise a job, promotion, or transfer opportunity without including the minimum or maximum salary for the position in the advertisement. The salary range may extend from lowest to highest salary the employer in good faith believes at the time of the posting it would pay for the advertised job or promotion or transfer. And it applies to New York City employers with 4 or more employees. Now, typically, under New York City law, we would count that globally. So employers who have 4 or more employees globally would still be have to comply with this New York City law. The law does not apply for job advertisements for temporary employment at a temporary health firm because those firms are already required to disclose certain information under the Wage Theft Prevention Act. And a violation of the law would be treated similar to a discrimination claim under the New York City human rights law, with a complaint being able to be filed with the New York City Commission on Human Rights, or there's also a private right of action available. We expect guidance on the New York City law to come out soon, but it has not yet been issued. So hopefully in advance of the May 15th effective date, we'll be getting more information on that. And then just a quick note on the pending legislation in California, which Sade will address in a moment. And in Washington State, it is certainly continuing this trend of including wage range information in the job posting or having some kind of affirmative disclosure on employers, an affirmative requirement on employers to disclose pay scale information. So that's the trend that we're seeing in this area. Now I'll turn it over to Sade. Thank you.
Thanks, Maria. So I am going to highlight some of the global pay data reporting requirements. And of course, when we say global, that would include the US, but for purposes of this presentation, we've kind of divided it into 2 sections. Global meaning outside of the US, and then US specific pay data reporting requirements. Next slide, please. So the trend that we see around the globe is a little bit different than what we've been seeing in the US. In the past, the US pay transparency laws have focused on salary history bands. And then as Maria just discussed, we're seeing a lot of progress on pay scale disclosure as well. That hasn't been so much the focus globally. In Ontario, they have a Pay Transparency Act that was passed in 2018, but still isn't effective. And that does have a prohibition against asking candidates about past compensation. And then the proposed EU Commission Pay Transparency Directive, which we'll discuss in a couple of slides, will also have a requirement about disclosure of pay ranges. But generally across the world, we're not seeing that focus on prohibiting questions on compensation or disclosing pay ranges. Their focus has been more on publishing statistics, preparing pay equity plans or reports, and similar presentations or requirements. The U.S. is starting to embrace some of that transparency aspect with our pay data reporting laws, but it's been kind of slow picking that up since our focus has been on pay scale disclosure and salary history bands. But as we'll discuss, we're definitely going to see an uptick on pay data reporting and making that information public. Next slide, please. We won't go into this slide in a lot of detail. We just like to illustrate that there are a lot of differences between various countries around the world with what their pay equity requirements are going to require of your company. So if you have a location in multiple different countries, unfortunately, there's no one rule of how you can comply with the pay reporting requirements. So your first step has to be that you are going to be first determining whether or not you're even subject to that country's pay equity reporting requirements, because most, if not all of them, have some kind of requirement about the size of your business or company before you are actually required to do any reporting. It's not uncommon for these global pay equity laws to require that an equality plan or some kind of equity plan be published or shared in some way. Sometimes it's a requirement that it's going to be published with the government. Sometimes it's making it accessible to employees or on an employer's website. And then sometimes there's differentiation of whether there's a unionized workforce and whether you're going to be providing the data and equality reports to that specific workforce. So it really is going to be kind of on a country by country basis as far as what's going to be required for your equality reports that you would be preparing. Most of the non-US laws have in place a lot of very specific details and requirements about how you're going to be preparing your equality plans or your pay equity plans and their contents. And as I mentioned before, it can differ by location. So after you determine whether or not you have to comply with a specific country's pay equity reporting laws, that's when you would then analyze what exactly is required on a country by country basis for the places where you do have to prepare the report, because it will differ depending on the location. So you can't really go to that next step of determining what's required for a specific country before you figure out whether or not you're even required to report. And then from there, you'll determine whether that report's going to be published, how you need to conduct that analysis, and what type of information is required to be included in that report. Next slide, please. I mentioned the EU Commission Pay Transparency Directive. A lot of you might be familiar with this when it first came out. It's kind of been slow rolling trying to get this actually approved. Once this is approved, it would apply to the EU's member states. So it's a pretty big deal, and while it would have a lot of requirements that you'd have to comply with, the nice thing is that you would see some uniformity as far as what is going to be required for certain pay transparency directives and requirements. So we have seen some progress on this pay transparency directive recently. There was recently an agreement between the EU member states and the Council of the EU that they could enter negotiations with European Parliament. So for that to happen, European Parliament has to adopt its own position on the transparency directives, and then they're going to merge that with that of what's been decided by the Council of the EU to determine what the final text is going to be. So our guess would be that we might see more progress on this within the next year, potentially getting it finalized even within the next year or so. And then we're not sure from there how long it would take for this transparency directive to go into effect. But this is in progress, and they have been still taking action on this to get the final text finalized in agreement. For this pay transparency directive, there are a few key pieces of information that you'd want to be aware of if you have locations in the EU. And it would apply to organizations that have 250 or more employees, and they'd have to provide information on their annual pay gap, and that information would have to be shared with their employees. So again, with other countries, we're seeing a lot of information required to be shared with employees. This would be no different. And it would be shared with the government as well. So everything would have to be publicly available that's being prepared. If there was a company that had a gender pay gap of 5% or more for any employee category, and it's not due to some type of gender neutral factor or can't be objectively justified, then that organization would also have to conduct a joint pay assessment with employee representatives. And then the EU member states would have to ensure that there was some kind of judicial procedure to enforce equal pay rights. So this is also a very unique requirement of, if you can't meet a certain threshold for your pay disparity, then you are going to have to work with your employees to conduct this pay assessment and figure out kind of what's going on and then publish that information. Any compensation that would be payable for equal pay breaches would be uncapped, so there would be no limit if you were required to pay back pay, and that would include back pay, bonuses, and other similar compensation. So the stakes would be very high for those companies that were found to not be in compliance with the Pay Transparency Directive. Next slide, please. All right, so that is a little bit about what we're seeing globally. Now we're going to cover the main trends that we're seeing in the US, and that's really going to focus right now on California and Illinois. Those are kind of the two big pay data reporting requirements that have come out thus far. Similar to how Maria discussed that there has been a lot of pay transparency requirements with the pay disclosure laws, I think we're going to be seeing something similar with the pay data reporting, because we're just getting started with California and Illinois, but the trend that we've seen with equal pay laws in the US has been on a state-by-state basis, very piecemeal, and kind of once one state starts adopting something, the other states follow and usually mimic a lot of the same language and requirements that we're finding in the earlier states. Next slide, please. So as I mentioned, the trend in the US has been a push towards greater transparency. The salary disclosure laws are really kind of the first step in having transparency around pay, and that's going to be connected to the pay data reporting laws as well. So we're first seeing the requirements that employees and applicants can and must be told about what their potential pay scales are. But with the pay data reporting, it's taking it a step further as well and requiring to provide information to state governments on what a company's workforce looks like and their pay data looks like as well. And the tricky thing about these laws is that, again, we're seeing it on a very piecemeal basis. So what we have in California is a bit different than what we have in Illinois. Maria mentioned there's a couple other laws that are pending as well. So it is going to be a little tricky to comply, and a report that you prepare for one state is not necessarily going to work for another state, especially because if you are limiting the data that's being provided to the specific state, it would be way overbroad to create just one report for your entire company if you are located in many different states. Next slide, please. We are in the second year of California's pay data reporting. This year, the reports are due by April 1st, 2022, because March 31st is a holiday, and there aren't going to be any deferrals this year. So the first year of the reporting, we got a little bit of leeway. There were some deferrals that were allowed, but now since we're into the second year, there are going to be no deferrals. So you'll have to get your report in by April 1st. And that's going to include companies that have employees who are assigned to a California establishment, living in California, working in California. So even if you're assigned to somewhere in Florida, if your employee is working remotely from California, they're going to be included in the California pay data reports as well. And then just a reminder of some of the key differences that we saw from the EEO is how you're calculating the wages that that employee is earning, and that you're including hours paid even if that employee wasn't working. So paid vacation, for example, paid sick leave. And then you also have separate reports for each legal entity. Next slide, please. there were a few changes that we saw for the California pay data reporting this year. One of the main changes is that the pay bands have been updated from what we had last year, so you cannot rely on the same pay bands that you were using for your report last year. This year we have updated pay bands, so the pay bands that you're going to be using for your reports need to comply with those new thresholds, or else your reports are going to be inaccurate. There's also a new and updated registration process, including a requirement that the person who completes the pay data report can actually see the certified report after it's submitted. And you have to register as an individual completing the report, and you have to register as the employer. When a new user logs on to the portal, you'll be able to search for an existing employer and link that account or create a new employer. So if you're not sure whether your report was submitted or when, you will be able to log on and conduct a search to try to see if you can find a report that was submitted for last year. If you submitted your report after July 1st last year, though, you should not need to re-register your employer. If you submitted your report before July 1st last year, then you will likely need to re-register. And the pay data reporting website has an updated user guide, updated FAQs, so they have provided updated information in line with what we're seeing for this year's reporting. Next slide, please. There is a new bill in California that was recently introduced, and this is what Maria mentioned earlier, SB 1162. It was just introduced February 17th, so just about a month ago. It's still pretty new, but it would make really significant changes in California on a variety of fronts. The first of which would be the pay data reporting. Aside from reporting the compensation information that you'd be reporting now, it would also require a report of the mean and median hourly rate of your employees. So that's different than what we have right now when we're looking at the salary ranges. There would also be an addition of penalties of $100 per employee for failure to file. Right now, there aren't monetary penalties associated with the California reporting, so this would be a new change as well, which could be potentially significant penalties depending on how many employees you have. And then another main change would be that the pay data report would be published online. So right now the reports are not published, but if this law passes or this bill passes, the reports would be published online. The second thing for this new bill would be salary information, and it would require that pay scales are going to be included in job postings. So similar to the trends that we've been seeing around the US, it would add that requirement about additional information, posting pay scales, and also giving the employee access to this information. So employees would be able to request to know the pay scale for their job position. And employers would also be required to retain the job descriptions and wage rate histories for each employee for 3 years after termination of employment. And that's really just so they can see if there's a pattern or practice of violations occurring. So if you don't keep your records for 3 years, then you could be subject to potential penalties in that way. The third kind of change with this bill would be job openings, and employers would be required to publish or announce promotional opportunities. One of the key factors to consider for this new bill is that there would be potential PAGA penalties associated with violations of this law if it were to pass. So financially, this could be a very, very significant risk of penalties. Next slide, please. Okay. I lastly wanted to briefly cover Illinois and the Equal Pay Registration Certificate. This could be an entire presentation in and of itself, and in fact it will be. On March 31st, we're going to do a separate presentation that's just on Illinois because there's so much to unpack for this law, and there's a lot of very specific requirements and questions that have been coming up. So keep an eye out for an announcement on the Illinois Equal Pay Registration Certificate webinar, but we'll just cover briefly some of the requirements for those who are interested. So the Illinois Equal Pay Registration Certificate requirement is going to require businesses to provide the Illinois Department of Labor with contact information to be assigned a deadline to receive a certificate basically saying that this company is in compliance with the equal pay requirements. Notices were sent to employers with May 24th and June 22nd deadlines to apply for certificates. We anticipate that there's going to be another round of notices sent, likely in May, for a September filing deadline. And then we're also expecting some proposed regulations to be published around March 24th or so. Future notices are going to be going out, though, on a rolling basis. And the Department of Labor has stated that it may take some businesses a year or so to receive their compliance date. Just know that they aren't going to excuse noncompliance just because you didn't receive a compliance date. So everyone is still going to be required to comply by March 23rd, 2024, even if they didn't receive a deadline from the Department of Labor. Whatever deadline you receive or due date is going to be the same for any subsequent filings, and they're going to be required every other year. Next slide, please. The application for the Equal Pay Registration Certificate has a few parts. First of all, it's going to be wage records, providing the most recently filed EEO-1 report. Unclear whether that report is going to be limited to the Illinois locations or not. And the second requirement for wage records is going to be an employee list, and that's going to be providing employee-level data for all of your Illinois-based employees, which is a number of specific factors that they laid out, including race and ethnicity categories, the county in which that employee works, start and termination dates, and then job classifications. The next requirement is going to be the equal pay compliance statement, and that's going to be someone attesting to the fact that the company does, in fact, comply with the Illinois Equal Pay Act and then any other state and federal anti-discrimination statutes. So with regard to the compliance certification, we anticipate that the guidance is likely to track the definition in the Illinois Human Rights Act about whether or not an employer is in compliance with these various non-discrimination laws. But again, we don't have a specific answer on that right now. Another key thing to note is that you are going to have to attest that there's a lack of wage disparity, which means average compensation for female and minority employees is not consistently below the average for male and non-minority employees for EEO categories. And then the other factors that you see listed on this slide, that essentially you're not making decisions based on sex or ethnicity, and that you're in compliance with all of the equal pay requirements. So it's a big deal, you know, to sign on the dotted line saying that you're in compliance with all of these. So the person who is signing to state compliance does need to know kind of what procedures are in place for the company to comply with these non-discrimination laws and actually what the company does. So if the Department of Labor were to come back with questions, that person would be able to answer the questions or get the answers for the questions. And then finally, there is a filing fee of $150. Next slide, please. Lastly, for the Illinois Equal Pay Registration Certificate, employees can request the data on an anonymous basis. So they can't get specific data about specific employees, but they can get anonymous data for their same job classification or title if they make a request. Otherwise, the data is going to be confidential to the extent it specifically identifies an employee or business. Aggregate data may be compiled by the Department of Labor and shared publicly. That's a may. It's not for sure that that's going to take place, but it's possible that the Department of Labor might choose a few exemplars and publish those data reports. And there are significant penalties associated with this as well, which would be fines of up to $10,000 as well. So I'm going to turn it over to Christy, who's going to talk a little bit about what we've seen with COVID and the Great Resignation.
Great, thanks. Next slide, please. So we all know that, COVID caused a lot of trouble for almost everyone, and employers are no exception. The current climate with the great resignation and talent shortages is really forcing employers to come up with creative solutions to attract and retain talent. But there could be unintended consequences there, like throwing off your pay equity balance. So workforces are constantly changing. That's nothing new. But some employers during the pandemic saw pretty drastic changes to their workforce. And those drastic changes mean that a company who conducted a pay equity analysis last year or a year or two ago maybe saw no issues in their last analysis, but could see very different results now because of these drastic changes to their workforce. In the last year or so, many employers have had to pay top dollar to replace their employees who have resigned, or offer sign-on bonuses to try to attract new talent, or give retention bonuses to keep current employees from leaving. And so we've seen this before where the market changes and you have to pay more for new hires, but the sheer volume of turnover and the market conditions during the pandemic are really highlighting this issue right now for us. And it's exacerbated by the fact that many employers reduced or eliminated merit increases or bonuses for their existing workforce during the pandemic. So whether you're looking at base pay, bonus, alone, or total compensation, you're likely going to see some pay equity issues that are stemming from these new practices. And what we're seeing, one of the things that we're seeing is that longer tenured employers may now be earning less than those new hires that you're having to bring in at higher starting salaries. Or sometimes the longer tenured employees are still earning more than the new hires, but not to an amount that's commensurate with, their additional tenure or additional experience. So take, for example, you have Bob and Sally both working for two different companies. They both in the same position, same salary, same experience, same everything. But if Sally left the workforce for 2 years during the pandemic and is now looking to return to the workforce, she now has 2 years less experience than Bob. But when Bob's employer hires her, she may be earning more than him because of the current market conditions. And so Bob's employer is likely just focused on filling their open positions, as quickly as they can, and not thinking about the unintended consequences of hiring a less qualified, less experienced Sally in at a higher rate than Bob. So it's something to kind of stop and think about as you're making these decisions. It might be necessary to bring in new hires at higher rates, but you also have to make sure, are you evaluating your existing workforce? Maybe they should be giving increases as well to maintain equity. And think about, is this something that you're budgeting for? To account for similar scenarios, some employers are trying to decrease costs by using sign-on bonuses to attract new talent, as opposed to bringing them in at higher salaries. And so that approach is effective at decreasing costs year after year since it's not a recurring payment. But the same type of pay equity issues, still come along with that, specifically when you're looking from a total compensation perspective. Remote work is another issue that has come into play in a big way during the pandemic. Oftentimes in a pay equity review, we will see geography as a legitimate reason why one employee is earning more than a similarly situated counterpart. But now with many employees working remotely and some continuing to do so indefinitely, employers really should be thinking about, number one, whether geographic differentials are still appropriate and justifiable. And if they are, whether or not that geographic differential should be given based on where the employee is physically working at their home, since they're working remotely, or what their work location is in the system. So these are just a few pandemic-related pay equity issues. I just wanted to go through them quickly because I know Annette has a lot of content still for us. But just make sure you're thinking about these things proactively, providing training and guidance to hiring managers, and be thinking about internal equity at every time a compensation decision is made. For those of you looking for CLE credits, the code is SS, as in Seyfarth Shaw, 3622. Again, that's SS 3622. And now I will turn it over to Annette to walk us through some of the key takeaways.
Okay, if we can jump right into the slides, as you've heard a lot of information, and this is just, I think, a handful of the issues that employers are considering. If you are a multi-state employer, a global employer, you have a lot of things on your plate that you're juggling, that you are considering when it comes to compensation and ensuring equal pay issues. Um, this is something that, as you know, as a result, it's really important to have a strategy. Having an overall compensation strategy is just absolutely critical to the organization, thinking about multiple types of issues. For example, when we talked about transparency, um, what we covered today was only the transparency that is required from a specific state and, the laws that they might have. But as I started the conversation today, there is transparency that's being pushed and discussed from multiple different stakeholders. So as an organization, thinking about what's the information that it will share, when are you going to share it, to whom will you share it, is all part of the consideration. Consider the impact that state laws are having across the organization. So for example, if you're doing one thing in response to Colorado or in response to California law, what are the implications across the organization? We know that many organizations are thinking through those issues, thinking how best to communicate and share that information with their various stakeholders. And at the end of the day, Christy talked about we've been talking for years about the war on talent, but the Great Resignation just increased that exponentially. So how can you use that transparency in a way that makes sense, understanding the privilege consideration, understanding that the backdrop of the things that we haven't talked about today is litigation. So there's a lot there to consider. Certainly engaging in these proactive pay analyses is critical. And we certainly recommend that those are being done under privilege, but you have to be more mindful now than ever before concerning the specific laws. Illinois, which we're going to talk more in more detail at the end of this month about, is going to require pay level, employee level information, data by county. Unless you're an Illinois employer, you're likely not thinking about compensation in that way or doing an analysis in that way. And yet that's one of the considerations that you're going to have to, evaluate as you move forward. What are the factors that matter for purposes of pay at your organization? Not just what's out there in general or what we might think or assume are relevant to pay, but what's actually being impacted, and is that data available electronically? If not, how do you get there over time? What's your strategy for example, incorporating something like geographic differences that you might not have, that might have been just handled anecdotally on a case-by-case basis as you do hiring? It's more important than ever to be strategic, to have a cohesive strategy on these issues. Do you have a system in place for evaluating compensation on a routine basis? So outside of the, maybe annual or biannual pay equity analysis that you do, how are you looking at compensation? Do you look at things like, your compensation ratio? Do you have an internal review that assesses, a peer review that assesses the impact of the new hire on the rest of your workforce? Or perhaps at promotion, are you doing a peer review there? Are you considering each component of pay? So it's not just about base salary, but how is it best for your organization to evaluate bonus or equity components that are also paid out? Do you have pay ranges? We've heard a lot today about those states that are requiring that disclosure of pay ranges. How do you go about doing disclosing pay ranges? What if you don't have them? How do you evaluate that? How do you set your pay ranges? Or excuse me, set your compensation? That's something coming up in Illinois that employers are going to be asked very specifically about. So for us, as we think about these issues, that's certainly where we are recommending that our companies head. As we have shared today, there are a lot of moving pieces. So as we go to the next slide, we just want to keep this conversation going. So today is Equal Pay Day. There's a lot of, as I mentioned in the beginning, a lot of press, but what we want to do is continue to have the conversation about pay equity and about different components of pay. Today was a high level overview, but our next webinar will be on March 31st, so be on the lookout for that information. And we will be breaking things down in a much more detailed way. And we're also going to be having a series of webinars focusing, for example, very specifically on pay transparency and some of the more strategic considerations I raised, the shareholder actions, pay equity studies, and remediation, just to name a few. We look forward to continuing the conversation. Thank you so much for attending our presentation today. And we thank you. We look forward to future discussions on this important issue.